welcome to a special edition of the DSR Daily. It is Friday, but it's also the last Friday of June, which means it's the last day of the Supreme Court term. They've come out with 6 cases today. And we thought, because the cases, at least 3 of them, were of some significant import, that we would go through them a little bit, talk about what they mean. And then on Monday, we will get our friend Dahlia Lithwick, a Supreme Court whisperer, to come in and provide us with a little bit more perspective. So it'll give you a 1-2 punch on what this is all about. Let's start by just going through some of the cases. Who wants to kick this off here?
I'll get us rolling. The Supreme Court ruled 6-3 to allow President Trump's executive order limiting a birthright citizenship to take effect in 28 states, while legal challenges continue in others. The decision, written by Justice Amy Coney Barrett, did not address the constitutional validity of the order, instead focusing on limiting the reach of nationwide injunctions by federal judges. The ruling suspends the executive order's implementation for 30 days to allow further legal review. Experts argue the order violates the 14th Amendment, which has long guaranteed citizenship to those born on U.S. soil, regardless of their parents' status.
Yeah, as some have pointed out, it's not that experts argue that it violates the 14th Amendment. The 14th Amendment is pretty simple. The language is pretty straightforward. If you're born here, you're a citizen here. But what this does is it gives the president the opportunity to ignore the law, impose a view by executive order, and then places a burden on those who are negatively affected by the law to go to court to protect their rights. If you can't go to court, if you don't have a lawyer, if you don't have the money, if you don't understand how the law works, you will be unable to protect your rights unless you get included as part of a class that undertakes the case. But of course, the class, it's getting a class certified in our system is quite difficult. So that's an issue. And that will remain the case until, of course, the Supreme Court makes a final judgment on the cases as they, in the terms of this case, percolate up to the top. Well, what does that mean? It means that the President of the United States can reinterpret the Constitution to suit his own needs, be completely wrong about it, but perhaps have months, perhaps years, in which his view can remain in place until enough courts, and there are 94 district courts in the United States, make a decision about it. There are those that say that courts, we're doing too many of these nationwide injunctions. But there are others that note that the inability to do a nationwide injunction creates chaos. And I think they will go back and make that case again in the district courts on the merits of the 14th Amendment case. Because if the 14th Amendment applies in California, but not in Texas, if you're a citizen in certain states, but not in other states, if you could get a passport if you live in some states, but you can't get a passport in other states, if you can be rounded up for being illegal in some states, but not in other states, imagine the administrative chaos that creates, not to mention the inequities in rights. So it is a ruling that, as Justice Sotomayor and Justice Jackson in their dissents noted, takes a step closer towards making a president a king, because they can hand down decisions that remain in effect for a long time. And it also puts essentially an unacceptable burden, in my view, on the poorest Americans who won't be able to afford the lawyers. It is hugely unjust. If you want to understand just how unjust, Justice Sotomayor decided to read her dissent from the bench. That doesn't happen very often. It's a 15-minute dissent. Go read it. Go see what she said. She is angry as I've ever heard a court justice, and Justice Jackson did the same. It's potentially a very destabilizing decision. And even as we're recording this, the President of the United States, who tweeted immediately, "Great victory. The 14th Amendment wasn't meant for everybody, illegals. It was, had origins and about the slaves, and we're going to now go and enforce this." He totally missed the point that the decision was not on the merits of his view of the 14th Amendment. And it began to do exactly what Justice Sotomayor warned he would do, which is impose his will and know that he would be able to do that with impunity for months or perhaps years. Um, uh, just essentially tossing the entire Constitution into a shredder. Every court that has ruled on this case on the merits has ruled against the president. Sotomayor noted that and said that should be significant. And of course it should be. And of course the court should have said at this point, no, 14th Amendment's 14th Amendment, it's plain language. But they didn't do it because every time they get the chance, or almost every time they get the chance to give the president a little more power, they take it. Next up.
In a 6-3 decision, the Supreme Court upheld a Texas law requiring porn websites to verify users are 18 or older, rejecting a First Amendment challenge. The court ruled that the goal of protecting children from explicit content outweighs the burden on adult users. Critics argue the law threatens privacy and could push adult content providers outside the U.S. jurisdiction, but the conservative majority sided with the state's regulatory authority.
Yeah, but again, where does it lead? What next? Is the issue protecting children? Do states have the right to protect children from content that they don't feel is appropriate to those children that isn't porn content? What if it's pro LGBTQ content? Would they be able to prohibit that? Well, let's turn to our third case. Riley.
In a 6-3 decision, which seems to be the common refrain, the Supreme Court sided with parents who argued that a Maryland school board violated their First Amendment religious rights by not allowing them to opt their children out of exposure to LGBTQ plus themed books in elementary schools. Justice Alito, writing for the majority, said the board's refusal to grant opt-outs placed an unconstitutional burden on religious expression. The ruling, criticized by liberal justices as potentially disruptive to public education, marks another win for religious groups before the conservative-leaning court.
First of all, I object to the terminology that Riley is using. Riley's not. I'm just picking on Riley. I'm kidding. But I object to the terminology that people typically use to describe the court. The 6 justices in the majority are not conservatives. Their interpretations of the law are radical. They often don't even care about the law. They don't care about history. What they're trying to do is advance a extreme political agenda. In this case, illustrates that. The liberal justices aren't liberals. They're, in some respects, by any definition, more conservative. They want to protect the Constitution. They want to protect the democracy. Justice Sotomayor, again, read a dissent in this case, and her dissent was focused on the idea that public education is supposed to allow people to get a range of views and allow administrators and educators to make the decision as to what those views are. But this essentially gives parents a veto power, saying, well, this doesn't conform with our religious beliefs and therefore it can't be taught here. We won't allow our kids to be taught it, which creates huge burdens on the schools. But not only does this have a chilling effect on open discussion, within the schools, but where do we go from here? What if the religious parents say, I don't think we should teach anything about Muslims here because Muslims are a threat, or Jews, or Christian groups that we don't agree with. That becomes an issue, of course, because the schools then become less and less able to address a broad range of issues, and there's less and less free speech in the schools. And when you think about this in the context of the right's broader war on education, it's pretty horrifying. Kicking DEI out of the schools, attacking the teaching of critical readings of our history out of the schools, Eliminating federal funding for universities that don't follow their views politically. This is what authoritarian states do. You would think that the court might assume the role of protector of the rights as established under our Constitution, but in this case, they don't. Alito, Thomas, and others are religious activists. They view the United States as that it's a Christian nation, first and foremost. And they want the mechanisms of the government to advance their views, which, by the way, is completely contrary to their view of what the system does when it promotes views they don't agree with, when they then attack the administrative state or the government for ramming views down the throats of people. Pretty harrowing ruling with the ruling on nationwide injunctions, two of the biggest, most significant, and most disturbing rulings of the year. There are three other rulings, and I would just ask that Min and Riley just quickly summarize them as well.
The U.S. Supreme Court ruled 6-3 to uphold the FCC's method of funding its Universal Service Fund, which supports phone and broadband access for low-income and rural Americans. The decision overturned a lower court ruling that had deemed the funding mechanism an unconstitutional tax and a violation of the non-delegation doctrine. Challengers argued that Congress improperly gave broad power to the FCC and that the FCC unlawfully delegated authority to a private company to manage the fund. The court's ruling affirms the FCC's authority under the 1996 Telecommunications Act to collect mandatory contributions from telecom companies for this purpose.
The Supreme Court upheld the legality of the U.S. Preventative Services Task Force. You'll never guess what the ruling number was, 6-3, that its members are properly appointed under the Constitution's Appointments Clause and accountable through the Health and Human Services Secretary. The challenge, originally rooted in religious objections to coverage for HIV prevention medication, ultimately focused on the structure and appointment process of the task force. Justice Kavanaugh, writing for the majority, emphasized that the Secretary's oversight and authority to remove members ensures constitutional compliance, despite dissent from 3 conservative justices. And then the last decision wasn't a decision at all. It was a deferral of the decision on Louisiana v. Calais, which was a case on the congressional map for Louisiana and whether or not it constituted as gerrymandering. And they have just decided to kick that can down the road.
So there you have it. Another big day in the Supreme Court and more rightward tilt and sense of empowerment by the court. But also, and I think this is a theme that has run through the whole session and certainly through last year's session as well in the Trump case and others, with more empowerment of the executive. We live in a country now with the most powerful president we have ever had. And the president has immunity. The president has a much greater ability to impose his view via executive orders. The state itself, the country, has far fewer capabilities in terms of regulation. And our country is changing. And I would just point out, and it's hard for some people to hear, that we knew it was trending in this direction. And when President Biden was elected, he said, well, I'll have somebody study the court. He set up a blue ribbon commission, and they studied it, and they did nothing. And in that case, as in the case of appointing Merrick Garland, who was a strict institutionalist and a member of the Federalist Society, who therefore did not pursue the cases against Trump that he could have. The Biden administration failed at its fundamental job. Democracy is weaker today than it was. And it is in part because that administration didn't do what it should do. Of course, the bulk of the blame goes to the Roberts Court, which will go down in history as our worst, and to Donald Trump, who will go down in history as our worst. But of course, the question remains, how much worse can this get under this court with this president? We'll discuss that on Monday with Dahlia Lithwick in a special episode of DSR. We hope you'll join us for that. In the meantime, we wish you the best for the weekend. Thank you, Riley. Thank you, Minna. By the way, Riley is away next week, so it's just going to be up to Minna and I to somehow muddle our way through this. But Minna does an excellent Riley impression. You'll all be very excited to hear that. Until then, bye-bye.